Good evening. Thank you for joining us today as we're privileged to hear from two scholars about checks and balances and the power of the purse as part of our week-long Constitution Day recognition. I am A. Kenyatta Greer, Senior Director of Communication at Emory University School of Law. I am joined by three of my esteemed colleagues. I'd like to introduce them to you and then turn the event over to our first lecturer. First, I'll invite you to submit questions in the Q&A function throughout this discussion. So let's begin. Dr. Edward L. Queen is Associate Teaching Professor and Director of the D. Abbott Turner Program in Ethics and Servant Leadership at the Emory University Center for Ethics. He also serves as a co-director of Emory's Institute of Human Rights. Previous positions include founding director of the Religion and Philanthropy Project at the Indiana University Center on Philanthropy and program officer at Lilly Endowment Incorporated. He received his BA from Birmingham Southern College, his MA and PhD from the Divinity School of the University of Chicago, and his JD from Indiana University School of Law, Indianapolis. Queen's work focuses on applied and professional ethics and the development and implementation of ethics programs in businesses, nonprofits, and governmental agencies. As a teacher, his goal is the formation of ethically informed and publicly engaged citizens. Queen has trained and advised numerous organizations on management and ethical issues, including the Federal Home Loan Bank, Atlanta, Belk, Ethisphere, Voya, Coca-Cola, USAID, SunTrust, Philanthropy Southeast, DeKalb County, Georgia, and Atlantic Public Schools. He currently serves as an advisor to Merlin Intelligence Technologies on AI and ethical decision-making, and a trainer for the U.S. Department of State's International Visitor Leadership Program. Queen is a recipient of the Laura Jones Hardman Award for Excellence in Service to the Emory community. Next, I'd like to introduce today's moderator. Professor Joanna Shepherd is the Thomas Simmons Professor of Law at Emory University School of Law. She served as Vice Dean from 2020 to 2023, and again beginning in the summer of 2024. In addition to her position at the law school, she currently serves as an adjunct professor in the Emory Department of Economics. Shepherd is a nationally recognized expert on judicial behavior, judicial elections, tort reform, and empirical legal studies. In addition to her recent book and several dozen articles, she's the author of two textbooks, The Economic Analysis of Law and The Economics of Industrial Organization. Shepherd's research has been cited by numerous courts, including the U.S. Supreme Court in Glossop versus Gross, 2015, and Williams-Yulee versus Florida Bar in 2015. In addition, she has testified about her empirical work before the U.S. House of Representatives Judiciary Committee, before the U.S. House of Representatives Energy and Commerce Committee, before the Committee on Law and Justice of the National Academy of Sciences, and before several state legislative committees. She also frequently teaches economics courses to law professors and federal state judges. And finally, Matthew B. Lawrence is Associate Dean of Faculty and Professor of Law. Lawrence researches and publishes on health law, administrative law, and addictions. In 2023, he was awarded the Provost's Distinguished Teaching Award for Excellence in Graduate and Professional Education. In addition to his teaching and scholarship, Lawrence possesses significant experience in the federal government. He is currently serving as a public member of the Administrative Conference of the United States. He previously served as Senior Advisor with the Drug Enforcement Administration, Special Legal Advisor to the U.S. House of Representatives Budget Committee, Majority, Attorney Advisor in the Office of Management and Budget's Office of General Counsel in the Executive Office of the President, and Trial Attorney in the Department of Justice's Federal Programs Branch. In 2016, he received an Individual Special Commendation Award for his defense of Affordable Care Act programs at the Department of Justice. Lawrence is a graduate of New York University School of Law, where he was a Furman Scholar, and Brown University. And he served as a law clerk to the Honorable Douglas H. Ginsburg on the U.S. Court of Appeals for the D.C. Circuit. I will now turn it over to Professor Lawrence to educate us all, and I will invite the other two panelists to join me in turning off your cameras for the time being so that our focus can be on Professor Lawrence. The next voice you hear after his will be of Vice Dean Shepherd. Professor Lawrence.
Well, thank you, Kenyatta, so much. And let me say first that after hearing those introductions, I would rather just be quiet and listen to my colleagues talk. But it falls to me to start off by doing the best I can to explain what's happening with federal spending programs and the power of the purse at this moment and over recent years. And so let me say thank you to those of you who are taking your kind of dinner hour to learn about the power of the purse. And thank you to those who are listening or watching to this rather than podcasts that might be more interesting or, well, not interesting to me, but to some might be more interesting. So I'm actually going to pull up a little slide deck for those of you who have visual, and I'll just start by saying, just this is like social separation of powers 101. Something that really fascinated me when I was beginning to work at the federal government and understanding how government works is the fact that the framers of the Constitution did not think a Bill of Rights would be very helpful. They were extremely worried that the federal government they were creating would allow somebody to become a king. They did not want a king again. They had just fought a revolution. And they did not think a Bill of Rights would be particularly helpful because it's just written down on paper. And if you have somebody who is holds tyrannical authority, their thought was, then no writing, no guarantee of a freedom of speech or religion or anything like that is really going to mean that much if you have tyrannical power at the top. And so instead, what they thought a lot about was to guarantee liberty and prevent tyranny by separating powers among branches of the federal government. And this is, you've presumably had this in civics, but you get Article 1 is Congress. Article 2 is the executive. Article 3 is the judiciary. And the idea is, here we are down here. We are hoping to live our lives free of tyranny. And the rule is going to be that rather than have one person like a king who can govern us, we're going to have Congress, Article 1, writes the law. We're going to have the executive, Article 2, enforce the law. And then we're going to have the judiciary interpret the law when there's legal disputes. And by separating powers in this way, we will prevent a king from developing and taking hold. And this is the vision of the framers. And I have to say that, it didn't take me long actually working in government. And any law student, it doesn't take long taking legislation and regulation, which we have as for our 1Ls in the fall at Emory, or constitutional law or administrative law, that you realize that this picture isn't quite how government works today. So here's the picture of how government tends to work today. You have Congress, again, that's 1, the executive, that's 2, and the judiciary, that's 3, these 3 separate branches. But what happens is Congress passes a law like, let's say, the Endangered Species Act. It passes back in the 1970s. And the Endangered Species Act is going to empower an agency like Interior. And Interior is overseen by the executive, but it's its own agency with its own secretary. And we could do Health and Human Services, we could do Department of Transportation. We have all these agencies. They're empowered by a law passed at one time. And then that law says that the agency can regulate, can enforce the law, and actually often is the one that adjudicates disputes. If you've ever had a Social Security dispute or a Medicare dispute, you usually actually have to go up to the agency before you can even get to the court. And so a lot of people wind up calling these administrative agencies that Congress created with these permanent statutes, they sometimes call them the fourth branch. But when I teach this, I always say, well, actually, because they combine the legislative power, the executive power, and the judicial power, if we're using like a tree metaphor, these are more like the trunk of the tree now. That's kind of everything runs through. And that's the challenge. Now, if you were following the 101 at the beginning, you'd say, wait, the framers would be upset about this. We were supposed to separate powers to prevent tyranny, to protect our liberty. We're going to wind up sad because we're now going to have individuals, not law, deciding our fate on major questions and things like that. And this is a major debate that happened in the first half of the 20th century. As we had these things form and we felt we needed them for a variety of reasons, and I think we do. We could talk about that. There was a huge debate about how are we going to preserve the separation of powers? How are we going to legitimize these administrative agencies and this administrative state that has so much power over us? And there's really, in practice, developed 2 kinds of answers. And let me tell you what they are. So first, there's a really ingenious practice, which is the power of the purse or appropriations. And this one actually dates back to the framers, and let me tell you about it. The framers said, well, the executive branch is going to have the power of the sword. They're going to be able to be the commander-in-chief of the army. But we're going to keep the power of the purse, the power of deciding how government dollars are spent. We're going to keep that with Congress. And immediately, at the very beginning of the United States government, the House and the Senate began a practice of, rather than funding the government in permanent law, remember, like the Endangered Species Act, that's a permanent law. You pass it, It's on the books, and if you want to get rid of it, you got to get through the House, the Senate, the President. That's going to be very hard to do. So something like the Endangered Species Act, that's a permanent law. But what Congress has done is it funds agencies like Interior or Medicare. It funds grant programs. It funds a lot of things 1 year at a time through annual appropriations. And this goes back to the framers who we could go back to Magna Carta. They saw this work for Parliament to get its power over the crown. But they fund the government 1 year at a time, which means, here, I'll draw my picture. Every single year, both the House and the Senate, both of them have to pass an appropriations measure to keep the spending flowing, to keep the executive branch operating. And this preserves tremendous ongoing evergreen power for the House and the Senate. That's why kind of today you see that Congress, it's only so often that they're passing big bills like the Endangered Species Act or something like that. But every year, maybe a few times a year, we get to see Congress moving when they have to pass appropriations. We've got another one coming up in a couple of weeks. And so through this power of the purse, it operates like the, you know how you don't bite the hand that feeds? The dog won't bite the hand that feeds. And agencies know that if they defy Congress, if they don't listen to Congress, then Congress will punish them in the next appropriation cycle. It might reduce their funding. It might do things, not give them the money they want. And so this preserves some legitimacy and some check on these agencies that would otherwise unify power to make law, power to execute, and all of that. And then the second check is, here, I'll go back to my color, is a law that gets passed first half of the 20th century. My colleague George Shepherd has a classic law review article about this, but it's the Administrative Procedure Act, which is abbreviated the APA. And the Administrative Procedure Act is basically like a constitution for agencies. It governs how agencies can go about wielding all this power they've been given. So the APA says that if agencies are going to try to regulate our lives, they have to follow certain procedures. It says that if the agencies are going to regulate our lives, they have to have statutory authority from the government, from Congress. So that means an agency can't do anything unless Congress has given it the power to do that thing. And so the APA is going to check that by requiring statutory authority. And then third, there's also this check where the agency's decisions get subjected to judicial review to see if they are arbitrary and capricious. And I'll just write arbitrary and cap, and you can't read that anyway. This is a check on sort of the rationality of the agency's decisions. And this system is basically what we've had for the last 70 years or so, where we have agencies with all this power that collapses the separation of powers. They are writing regulations, they are enforcing those regulations, they're adjudicating disputes. But enduring influence for Congress is preserved through appropriations. And then a check on the way that agencies exercise all of that power is preserved through the Administrative Procedure Act. And I should draw a picture. You can sue under the Administrative Procedure Act and go up to court, and you can sue. And that has been the kind of status quo since the mid-20th century. However, and I'll stop there and come back to me, we've seen in the past several presidential administrations kind of steps towards defiance of Congress's power of the purse. We had an example in the Obama administration where the administration had funding for cost-sharing reductions. They were sued by Speaker Boehner of the House of Representatives, alleging that they violated the power of the purse. We had cases in the first Trump administration about sanctuary cities, about wall funding. We had a case in the Biden administration also about wall funding and also student loan forgiveness. These kind of particular big ticket, major presidential priority examples of departures from the power of the purse and then litigation that came out of that. And what we've had since January is sort of a systemic expansion in the degree of executive defiance of the power of the purse and defiance of the Administrative Procedure Act when it comes to the operation of spending programs. And so for whole agencies, for whole institutions, for industries, we see conditions on funding coming from the executive branch, not from the legislative branch. We see cutoffs contrary to the direction of the legislative branch, and we see threats to funding that are not coming from statutes. And these actions are unilateral executive actions. They're coming from the agencies. They may be even coming from above the agencies, from the White House or OMB. And when I say it's unilateral, what I mean is there's there is often not a plausible argument that that what's happening is actually consistent with the statute or the appropriations laws that were passed by Congress. So I'll give you an example of this, and I shouldn't have taken my screen down. But here's a decision, I think a few days ago from district court in one of the pending litigations. And what the court said is, this is after months and months of litigation, the court says, defendants' reasons for not developing an argument. So the government hadn't even developed an argument that what it was doing was lawful. And this is the court talking. The reasons for not developing an argument over numerous months and opportunities given may be many, including that having changed their position, there is not a plausible interpretation of the statutes that would justify the billions of dollars they plan to withhold. Whatever the reason, defendants have given no reason, and the court winds up, in that case, enjoining it. And that brings me to another piece of what's happening here is we have this systemic unilateral executive disruption of spending programs, and then we have a lot of litigation. So as you would expect in our system, if there's concern that the executive branch has violated the law, people go to court and they've been seeking relief. And in many, many cases, the courts have been granting that relief. So I looked at Just Security's litigation tracker last night, and at last check, we've had 48 cases, 4 cases, reach the point of a court deciding whether or not to grant an injunction, for the time being, against an executive action disrupting funding. And of those 48 cases, 35 of those cases, the courts have granted the injunction and said there's a concern here and it's causing irreparable harm, so I'm granting an injunction. In 13 of those, they have denied the injunction. So that's a grant rate of, well, you could do the math, but of course that's the sample of cases that have reached decision, which is not a perfect sample. Joanna's Professor Dean Shepherd is an empiricist and could go into that. But the core point is that's the dynamic right now, is that we have unilateral executive disruption of spending programs, and then we have extensive litigation trying to kind of sort out concerns about that unilateral executive disruption of spending programs. So to sort of take home what's happening right now, there's unilateral executive disruption. The courts are checking to some extent the unilateral executive disruption, but the check is incomplete. And I want to emphasize that it's not like everyone who's had disruption contrary to statute has been made whole. Instead, it's some fraction that someone could calculate. I haven't yet figured out a way to calculate, but there's 2 reasons that a lot of the effects of the disruption are not mitigated by this possibility of judicial review. And the first reason that the threat of illegal, oh, look, my camera did that thumbs up. So sorry about that. Well, anyway, maybe it's appropriate. But the first problem, or the first challenge for the check of judicial review on unilateral executive disruption of spending programs is that over those years where Congress was overseeing executive spending through appropriations and it was working well, the courts developed several very deferential doctrines where they say we're going to stay out of spending disputes. Congress and the executive are working together well. We, the courts, are going to butt out. And there's a number of doctrines. One's Lincoln v. Vigil about judicial reviewability. Another is interpretation of the Tucker Act about tort suits and when the timing review. There's mootness doctrines, ripeness doctrines. But the upshot of all of this is that the executive can do something illegal to you with regard to spending, and then you go to court, and the court says the door is closed. And it's closed because of these doctrines we've developed that are meant to leave spending disputes to the dynamic of Congress and the executive sorting them out when things were working well. And that's one reason that a lot of this doesn't get checked by the courts. And then a second is that it takes courts a long time to intervene, and they don't really have remedies to make people whole if they're subject to illegal action. So, the metaphor I would use is just like if your neighbor comes up to you and says, hey, that tree that you've got on your property and the branch is leaning over my property, if you don't trim that branch tomorrow, I'm cutting the tree down. And you might be a lawyer and know that the neighbor has no right to cut down the tree. And you might know that if they cut down your tree, you could first take care of it and then sue and then maybe get damages in like a year, right? But you're probably going to just cut down the branch, right? Or well, maybe it depends on the person, right? But the core point is that the first mover in doing something unlawful can have a lot of leverage over someone that they're threatening, regardless whether at some point in 6 months or 2 years, a court would intervene and potentially do something to make them whole. So that creates this status quo dynamic that we have right now of pretty widespread unilateral executive disruption and threats of disruption to federal spending programs through cutoffs, conditions, and threats. And then a lot of active litigation and exploration of kind of what are the limits of that litigation. And I probably have another 10 minutes. So what I'd like to do is, I've just talked about like what's happening. Let me talk about some of the consequences of what's happening, because this really is, I'm not going to pull up my painful picture again, but this really is an epigenetic shift in the way our kind of government functions, because we've shifted away from spending being this area where Congress checks the executive and influences the executive and kind of makes up for the collapse of the separation of powers through the development of the administrative state. And instead of that, spending is now becoming another area of executive control and action. And so there's 6 consequences I would lay out, and I really think it's important to separate these because they're really different and they affect how you understand all of this. And I want to reiterate, well, I don't know that I said this. I am doing my best to just describe what's happening. I don't mean to suggest, like I'm a lawyer. I like the law, but I don't even mean to suggest when I say there's executive law breaking that that's bad or good. That's in the judgment of the audience. Again, I have my own views. I do like the law, but people are going to form their own judgments. I don't mean to suggest that. I'm just trying to describe what's happening. So consequences of this, I would differentiate 6. And I would focus on people first. I think it's always important to focus on people, like our coworkers and neighbors. And then power questions, the separation of powers questions I started with. And then talk about kind of government capacity. So let me go through those. First, for people, the first big impact of this on people and institutions nationwide is that there is now a de facto kind of lived fragility to any program, business, operation that relies on federal spending. We lived for a long time in a situation where if you relied on federal spending through grants, through small business, you name it, if you relied on federal spending, you watched carefully the congressional appropriations process, although maybe you could kind of trust that Congress supported your program and it would be okay. But now everyone has to worry that there might be presidential disruption at any moment. And it's not just in the legislative process. It could just come at any moment. And this is like, I think you could compare it to a risk that you have to insure against, or maybe a tax, that even if an entity is not actually affected by this unilateral presidential kind of disruption of spending, they have to take precautions. And those precautions are costly. Right? So maybe rather than leverage all of your budget and build, you say, well, I'm actually going to hold back 10% because if I did become subject to a disruption, I would want to be able to not have to fire people or something like that. And so everyone winds up kind of paying this insurance tax against the risk of presidential disruption. That's one effect. A second effect is for kind of the most targeted institutions, there's now greater intrusion of federal influence on their behavior. So, the idea of the separation of powers and liberty is that individual behavior is, its regulation by the government is checked in various ways. And there's now risks that behavior can be regulated in ways that circumvent some of the constitutional checks. A number of those 35 cases granting injunctions express concern about effects on expression and speech related to some of these government threats. And so that's playing out for individuals who are subject to these and institutions. A third is so that's people. Now, effects on power. So first, for congressional power, it's diminished. So Congress's power is diminished because its influence over spending programs is now reduced. It has less control over spending. And the flip side of that is that executive power is enhanced. And it's a huge debate in admin law, whether we want more executive power, more legislative power. So if you like executive power, maybe you like more executive power. But if you like legislative power, you might not like that. And then a final effect of all this is on the capacity of the government to do things. So if I can go way back to the framers, before our federal government, the first government that the founders created was the Articles of Confederation. They just had a king. They did not want another king. So they created a federal government that didn't have power to really generate revenue, didn't really have power to engage in armed conflict, and it was powerless. It was feckless. It couldn't do things. And after not that long, they came to the conclusion that we need a federal government that actually has the capability to build and defend and fight and invest and do all the things we rely on government to do. And so they created the federal government. And they then put in the checks and balances to try to prevent it having been empowered from getting so powerful that it became a tyrant. But they created that. They were very concerned with the capacity of the government. And there's two ways that this kind of rise of presidential unilateralism when it comes to spending are affecting capacity. First, for Congress, like we complain that Congress can't legislate, and what I've heard from members of Congress and would also just kind of predict is that that the way Congress got things done for the last 20 years is compromises in spending legislation, right? I don't want to pass the bill, but you're going to give me this money for my district, and and you make a compromise in passing legislation, you make a bargain. And what this rise of executive unilateralism has done is makes it really hard to compromise for Congress, because you can't rely on the thing you write in the statute actually happening by being executed by the executive branch. You now have to worry, hey, maybe I get this deal, but maybe you're not going to honor it because I had the deal last year in the other spending legislation. And it's not being honored now, and it's in litigation. And so it then becomes harder to compromise. I agree with predictions that a shutdown in 2 weeks is more, or it might be closer than 2 weeks, but that it's more likely because it's harder to find that compromise because people can't necessarily rely on what the executive branch will do. Unless we could get to this, the Congress changes the law to try to give itself more assurance. And then a second challenge is for agencies. Every agency now, it's more costly to do business. If you're going to hire a contractor, if you're going to give a grant award, you get less bang for the buck now because whoever you're working with now can't trust you to the same extent. And it's kind of like the nation's functional credit rating as a hirer, not the national credit rating that Moody's does, but the government, the Department of Interior's, HHS's credit rating when they're doing business with a grantee is going down, and so then it's going to cost them more to get the same level of performance. So those are some major effects of all of this. I don't want to monopolize my time, so I could talk about next steps, what's going to happen in a year, or maybe even why this happened, but maybe I'll save that for the Q&A if people are curious. That's my best understanding of kind of the lay of the land as we sit here in September when it comes to the power of the purse and checks and balances. Thank you.
Thank you, Matt. That was so fascinating. I learned more in the last 20 minutes about this stuff than I've learned in a long time. And I think our students are so lucky to have you and to someone that can explain these topics so well. I will now turn it over to Dr. Queen, who is going to comment and give some of his own thoughts and questions about Matt's work and presentation, and then we will go to Q&A after that. So, Dr. Queen.
Thank you. And thank you, Professor Lawrence. Tremendous amount going on there. And as Professor Shepherd said, probably one of the most exciting talks I've ever heard on basically issues around administration and legislation. But I want to start similar to where Professor Lawrence did with this entire question about how we started here with the Constitution. And I want to start off by saying that if we think about it deeply, every decision about allocating resources is an ethical decision. It's a decision about what goods we as a society want to produce or what we want to not be produced. And then also how we're going to pay for those goods or how we're going to sanction people that kind of violate them, right? Now, the challenge fundamentally in a liberal, pluralistic, democratic society is that there are going to be multiple goods. And the challenge of then kind of determining how we kind of write those goods as things that the state wants to help you produce or kind of prevent you from producing is really what happens in legislation, right? And as Professor Lawrence was saying at the end, part of the way this works, or part of the way this traditionally has worked, in the legislature is through compromise, right? There's a reason that the founders put the power of the purse. The bills for money have to begin in the House of Representatives because they felt that the House was the closest to the people, would have a sense of what they valued, what they felt important, what they thought the state ought to be doing. And so therefore kind of bills had to kind of around money had to be initiated there, right? And then because different states, different regions, different industries, different groups would value those goods differently, you negotiate, right? And as Professor Lawrence was saying, part of this is, I may not be really in favor of this, but I need your support here. Or it's a way of kind of building coalitions, right? I mean, there's a reason that that what used to be food stamps is now SNAP, et cetera, is in the Department of Agriculture, right? It's a way of providing a necessary social service and serving American farmers, right? You get a bigger bang for the buck, right? Think about everything that got lumped into the National Defense Education Act in the 50s, everything from building highways to kind of training people in under resourced languages, right? Because we need this for our defense, right? So there's this issue of compromise that kind of is built into the process, but the success of that is contingent upon the ability of the legislators to kind of be convinced that this is going to work, right? And the challenge that we've seen, that the kind of Professor Lawrence kind of laid out, is that what happens when you can no longer count on that. And if you think about it, this also begins to kind of get at it, an undermining in a very complex way, the very reason, the very purpose of law, if you will. Because one of the things that the law ought to do is give us a level of predictability, right? And if agencies, if contractors, if people that are doing the business that government has said it wants to get done can't predict, can't be assured that they're going to get the work done, their costs, their consequences, right? And in tremendous ways, it really begins to not only create dysfunction, but on a macro level really begins to kind of undermine fundamental trust in the entire system, right? If we can't believe, if we can't be convinced that the system is operating, if we can't be convinced that promises that are held out to us are going to be maintained, what do? Right? And I think that fundamental reality is creating this kind of going to create a kind of level of dysfunction throughout all the system, right? Second, the kind of arbitrariness that Professor Lawrence mentioned is really going to kind of play a major role in undermining the entire process of maintaining the infrastructure that needs to be in place for government to do the things it wants to do, and then also to a great extent undermining the infrastructure that is basically position the United States at a level to kind of produce economically, technically, functionally what it's produced over the past 50 to 100 years. So it really kind of threatens in significant ways to undermine the kind of very bases of what has given the country its strength. So that's part of what's going on, right? Now, on the other side, there is this challenge, and he kind of talks about that with kind of, Professor Lawrence talks about this when he discusses the way that laws have been written, really over the past 70 to 80 years, at least since the New Deal, if not somewhat before, in that they're complex, right? And Congress can't do the work that the agencies do. Um, and Congress doesn't have as much of the expertise as people in the agencies do. So they've handed over to some extent that authority to people that they presume have a level of expertise. But they control historically these experts through the power of the purse, through the annual appropriations, right? And this begins to kind of get at a kind of fundamental substantive question about who ought to make decisions about what gets done, right? Is it people's elected representatives? Is it technicians, specialists, technocrats who know a particular field? Where ought decisions be made? And that is a really kind of challenging reality that the United States has faced over the past multiple decades, right? Who do we trust to make decisions? And the negotiated compromise in the past has been, we're going to trust the experts to some extent, but we're going to control them because of how we handle the money. But what happens when that entire process, on one hand, gets undermined through this kind of arbitrary executive decision making and a fundamental process of developing mistrust in the entire system? And Professor Lawrence was particularly gracious in kind of refusing to make judgments. As I tell my students, I'm an ethicist. My job is to judge you. But these kind of decisions about so many things that have been kind of taken out of the hands of experts and placed in the hands of others, which really have kind of exacerbated this kind of growing mistrust in all institutions in the United States, from government through business, through nonprofits, right? And when this kind of mistrust happens, we really begin to undermine the entire functioning of the democratic polity, right? And we're going to return to some sort of level of clientelism where people only work with those who kind of share their views or to whom they owe something or who owes something to them. And that really is kind of along with this kind of opposition to the development of a king is something that the founders were concerned about. They didn't want to create a government that was kind of based on personal connection, and an issue of kind of quid pro quo in terms of relationship, in terms of what you get, in terms of allocations. And you could see, as Professor Lawrence suggested, that this becomes this spiral that greatly serves to kind of undermine much of what the system was designed to do. And that does kind of bring at the next point, right? The founders did not want there to be a king. The last thing they wanted was for an individual to basically be making decisions that control the lives of people in the United States. And one of the results or one of the consequences of executive control over money that we've seen happening more and more is that it really does give an individual control that they'd never been granted by the Constitution, right? And it weakens not only Congress, but it kind of weakens so many of the democratic values that we hold dear, right? If an individual can punish organizations because the organization speaks ill of the individual, if it upholds policies the individual opposes, um, what does this do to kind of the core freedoms that we really felt the United States stood for? So all of this is going on. And then what do we say about a court that's basically kind of abrogated its responsibility in kind of controlling executive overreach, right? Yes, there's a kind of significant separation of powers issues that we might want to think about. But at some point, if there's a wrong, there has to be a remedy. And courts failing to kind of step in to remedies these significant wrongs, or at least what arguably could be conceived as significant wrongs, really kind of puts us all in limbo, right? We're never going to be made whole. We're never going to be able to kind of fix a situation if it's never going to be fundamentally and finally adjudicated. So these issues are of such significance, not because my ox may be gored because I didn't get this money, or I have to lay off staff because I didn't get this money. They're significant because they basically serve to dismantle everything that this system was designed to create. When you turn things over to the decisions of one individual or one branch of the government, if you will, you basically undo what the United States was designed to be, right? You know, as Madison says in Federalist 51, I believe, you know, the purpose of government, first of all, first thing is to get it to control the people, and the second is to get it to control itself. And the founders realized that you can't, it's very hard for people to control themselves. You give people power, they're going to act on it. So what we do, or what the goal that we were supposed to do, was basically to control people's will to power, the different branches' will to power, if you will, by putting them against each other, right? And as Madison himself says, you know, the kind of ego of not wanting to give up my authority, the authority of my branch to another branch is going to serve to kind of keep each branch exercising its particular power. Now, we have to ask ourselves the question, what's the result when one branch may unilaterally, for any number of reasons or any number of ways, gives up its power, hands it over to another branch, no longer acts as the founders expected to, egotistically to maintain its power, its authority, if you will, and turns it over, right? Where are the limits that we really want there to be on particular branches, right? What's to stop overreach? Those are the questions that loom over everything we've been experiencing, going back to Nixon, if not before, right? You know, what is or will be or are the consequences of what many have kind of called the imperial presidency? Now, there's a tension here, right? The complexity of the world in which we live means that individual legislators may not have the knowledge they need to make powerful or appropriate or good decisions um, about particular things. There may be a need to some extent to hand things over to specialists, to technicians, to experts. Um, but the experts aren't elected. The experts don't have to face the voters, right? And so really up until recently, as Professor Lawrence kind of pointed out very, very graphically, if I may, um, well, we've balanced that. We've balanced it with the kind of annual appropriations. Yes, annual appropriations are negotiations, they're compromises. Um, but to some extent, that's not a bug. It's an element of the process. Because compromise is what makes it possible for a complex, pluralistic, liberal democratic society to function in the ways it's supposed to function. And when compromise no longer is necessary, no longer is sometimes forced, then why should I bother? I get no benefits from it. What do we do? And the consequence is I don't compromise. I can look pure, I can look perfect, I can jump up and down and scream and holler and stamp my feet. And I can go back and say, I held on to what I believed because there's no value in compromise. This weakness, this failure is really what's going to kind of serve to make it terribly, terribly challenging to kind of make government functional again. Because there's absolutely no, maybe an overstatement, but there's minimal incentive to get work done. There's no incentive to kind of engage with competing voices. There's no incentive to kind of move things forward to make them work. Because I can never trust that the decisions I make, the compromises I make, are going to be implemented. What this does, what the weakening of the power of the purse in Congress, what the weakening of the balance of powers does, at some point, it creates the worst thing a democratic society can experience. It creates massive amounts of distrust. And if people don't trust the system, they're no longer going to be engaged. They're no longer going to participate. And they're going to turn to other ways of accomplishing their goals. Now, to kind of close, kind of raising one final issue. And I go back to the founders, right? Founders had a particular challenge when they're trying to figure out what the executive was supposed to look like. And the challenge was a 6'3" redhead that everyone knew was going to be the first president, George Washington. And no one wanted to kind of write in limits on the presidency because they felt it would be an insult to Washington. And they struggled. And in fact, they actually passed the kind of articles for impeachment before they even kind of figured out what the executive was going to do. They reached the impasse, and someone rose and said, look, the second president isn't going to be someone we trust necessarily. Therefore, we've got to write limits on the executive, not knowing what this person is going to be like. And it burst the dam. They move forward. We have a government of laws at best, not a government of people. People are defective. They could be greedy. They could be grasping. The entire purpose of what the Constitution was designed to do was to create a functional process, knowing that we're dealing with defective individuals, or at least possibly defective individuals. We don't want to hand power over to one group, whether it's a singular executive or a multiplicity Congress or an overreaching court. Failure to recognize the complexity of people means that we fail to kind of move this forward in a way we ought to. Thank you.
Thank you so much, Dr. Queen. That was fascinating too, and a slightly different perspective on this. I've got various questions that I think I have in my mind who I'm going to ask the question to, but I would love each of you to jump in, because I think a lot of the questions that I ask could really be answered from each of your perspectives. Professor Lawrence, I'm going to start with you since you haven't had a chance to talk in a while. The economist in me kind of wonders why this has happened. You mentioned it's not just the current administration. Going back as far as Obama, we started to see little kind of, little instances of this phenomenon, that maybe has grown a lot in the current presidency. But what do you think? Like, if you put on your historian hat and you were thinking back to what has led to several different executives kind of changing this very delicate balance that we had for a long time, what would you point to?
Well, yeah, great question, and I can only speculate about why this has emerged, and I think that you could think about internal answers, by which I mean answers that have to do with the government system itself. And I think you could think about external answers about culture and society and the way we communicate and things like that. And so maybe I'll start actually with external answers, especially if we're trying to think across presidents. we have had in the last 30 years or so, not an increase in polarization as I understand it. From what I understand, actually, the median kind of view on the left and the right on policy questions has not changed very much in the last 30 years. But we have had a major increase in affective polarization. So like in surveys of, would you be upset if someone from the other party married your child? 30 years ago, it would be like 5% would say yes, and now it'll be like 50%. So it's actually not so much about policy disagreement or rational questions, but more about emotion. And I personally am just on that this is not appropriations and power of the purse, but I do subscribe to the view that the communications technology through which we interact has a major impact on the way government operates. So, parties emerged, even though George Washington didn't want it, because people needed to get in groups and kind of sort things out, and you couldn't fight it. And then at the turn of the 20th century, we had like magazines and periodicals that people kind of represented groups that people felt connected to. And so the suffrage movement and the temperance movement all fought against parties. These were major political movements that people lived and breathed and felt was important to them, but they weren't party. Temperance would play parties off each other, and so would suffrage. And then mid 20th century, you get a few major networks. They are forced by the FCC to be balanced. And so you start to get polarization of right and left, and those drive away the magazines. And then, of course, since cable news, we get the networks themselves polarize. So they start to go right and left. And then the parties become more polarized, and Congress has dysfunction. And then social media comes along, and their business model is to get us hooked. And polarization has really helped them with that. And so they drive, if let's put it this way, if we want this webinar to be watched by a lot of people on social media, one of us should say something incredibly extreme very soon, right? Because then it'll go out. But if all we do is try to say our best understanding of the way the world really is, then social media won't amplify it, and then that doesn't drive extremism. So I do actually think that polarization, effective polarization, then gets you people being able to willing to support someone and look past the law and underlying values and what's good for the country. If you're and you could, anyway, we could go back in this, but you could get quotes of Biden saying, I can't do that, and then doing it, right? And maybe losing fewer of the supporters than maybe Reagan or Carter would have done. So anyway, you could speculate around those external considerations. I think there's also internal ones, like to the government process. In this particular, recent history, I would say, and you could tell, I could go on all night. One big thing is, I think, in any presidential action, there's a question of whether you're going to care more about the effect of the action, how it changes the world long term, or the expressive impact of the action, how it changes the conversation today. And that's, of course, been true of all presidents and of all times. And often you have to balance. Do I actually want to change the world long term, or do I want to get on the news tonight or change the conversation? And doing illegal things, doing things that a court may, in 4 years say was unlawful and award billions of dollars to somebody, that may not be effective. That you can't build a wall doing that. But you sure can change the messaging in the short term. And so if you just look past administrations, I think about during the Biden administration, the rule banning non-compete clauses that everybody thought was illegal. I don't know, predictions were all that's going to get struck down, but it sure drove the conversation for 8 months. So from an executive perspective, it might have been smart if what we're trying to do is control what people talk about rather than actually build things and change things. So that could be another trend that's relevant. And because this is Q&A, I'll stop my answer there, but I could filibuster this for the next 40 minutes.
I'm sure. Thank you. Dr. Queen, do you have anything to add on that? How we got to this point, not just in the current presidency, but kind of over the last few?
Yeah, I want to kind of go to a higher elevation than professional arts, because I do think that there are cultural issues at stake here. And I really value the fact that he used the word expressive. The very fact that we really kind of turned into a culture where everything is about subjective feeling. And again, he said, yeah, do I care if my child marries somebody who belongs to a party that I abhor, right? Everything's become about feeling and less about substance, right? And clearly this has been exacerbated by social media and so many other things that's going on. And then you find yourself in this spiral going on and on all the time. And so, yeah, it's a challenge, right? And politicians being politicians um, do that, right? I'm going to make the statement that's going to kind of get me visible, that people are going to say, wow, that's incredible or whatever. And I'm there, right? So yeah, the cultural challenges of kind of addressing this are immense, and the social media has really kind of made them so much worse.
Sorry. Thank you. Yes. Okay. Let me switch gears a little bit. You both mentioned the courts in your presentations. So I would want to know how, I mean, we've always thought of the courts as a check on a lot of kinds of behavior. So what do you make of that and how that's fitting, how the court is fitting into this whole picture? Matt, you mentioned, the number of cases and how many they were letting this go versus not. But what is your take on that? Maybe even in light of what you just talked about in terms of like, where we are as a society. Yeah.
Who should start? Edward, do you want to start this time or should I?
You go ahead, because this is probably the moment I say something outrageous.
Okay. Well, good, but that's going to get us on the news or whatever. So
Well, I'll say something that is outrageous. I'm a big court booster. The courts have to respond to to changes and build something that's going to last for decades. I don't think they're wrong to be careful. As I mentioned, like in this last 8 months, just in funding, we've had 48 cases reach a decision about an injunction. That's really fast too. Like I defended government actions. A typical case is 10 months or 12 months before you get any kind of decision. For a court to be willing to do an early judgment really requires a lot. I could go into the standard. And we do have 35 orders enjoining, and many of those are enjoining across whole programs, some of these funding disruptions. We have 13 denials. We could get into what the Supreme Court's been doing, and we really could. But I will just say also that I think that I've been teaching my students for a few years now that it's my view that maybe others would not disagree with, that the Supreme Court, including kind of the majority, has seen the creeping trend towards executive power with concern. And we had 3 major decisions during the Biden administration that seemed like they were trying to tyrant proof or kind of check executive power, maybe 4, depending on how you count it. So there was a huge decision reversing the Chevron doctrine, which is the Loper-Bright case. Now, this was during the Biden administration. So people who like the Biden administration thought this was a very Republican ruling. But what it did was say that the executive does not get power from ambiguous statutes. So it's a major knock against executive power. There was also a case requiring consideration of reliance interests when agencies change policy, and that makes policy stickier. It's a conservative decision in like a Burkean perspective, but it again takes power from presidents. Third case was on the major questions doctrine. They basically, if you look at the cases that on the major questions doctrine, they say that it's a doctrine that makes it harder for presidents to like do big innovative things with new interpretations. That's now coming up in the tariffs case that'll be argued in November. And I'd even point to the Trump immunity ruling, which people think immunized Trump. But the Supreme Court, of course, is never thinking about the case in front of it when it's deciding a case. It's thinking about the next case. And the Trump immunity ruling also prevented the Trump administration from prosecuting Biden officials. And so all of these decisions look like the court is trying to actually diminish executive power in some ways. Now, we could talk about removal decisions and independent agencies and things like we could talk about that. But that is why I do see the courts as a really meaningful check here. And Edward, please jump in. Often when I'm in these conversations, then somebody comes in and tells me how wrong I am, and maybe I have no good defense, and we leave it at that.
No, your points are well taken. I guess my reading sees the court as depending on which level courts about which one is speaking, is much more schizophrenic here. The cases you laid out clearly suggest that there's some concern, right? On the other hand, a lot of the recent rulings seem to kind of suggest a court that's less reflective, perhaps, on the consequences. And I'm always reminded of the story about the Jehovah's Witnesses flag cases, right? When the one that they basically said, first case you can kind of expel the kids, and then everybody starts jumping in with all these other laws, and Justice Frankfurter is on the steps of the court, and Mr. Justice, shoot, my mind went blank. Well, the other justices come up and says, you know, Hugo's about to change his vote on the Jehovah's Witness case, and Frankfurt says, why? What has he been reading? And the response is, he said, read it. What has he been reading? The Constitution says, no, he's been reading the newspaper. What are the consequences long term of some of these decisions that seem to open things up, or even more concerning, seem to kind of minimize the likelihood of getting a remedy down the line, right? I mean, that's a big concern of mine, is that how much do people have to suffer by your kind of reluctance to address a fundamental challenge up front, right? Now, again, one can be charitable and say that the court is being cautious about some very, very complex reasons. On the other hand, you have to ask the question: is it really kind of knuckling under, and failing to kind of live up to his responsibility? And there's an ambiguity there, and one thinks that sometimes the future is going to solve the problem, but sometimes the future just basically kind of leaves the problems hanging out there for far too long.
Thank you. We've got about 10 more minutes and I've got 3 questions. I've got 3 from the audience so far, and I'd like to throw in one of my own too. First of all, I think this is probably to Matt, Professor Lawrence. How many denials are upheld, particularly in light of Trump v. CASA? Oh, you're on mute, Matt.
Oh, I have to say that I'm not, what I've been able to do is count at this moment how many injunctions are on the books from the Just Security Tracker, which, like I said, is 35, and 13 kind of denials. It is a question of, like, as you trace up through the circuit courts and the Court of Appeals, like, how are things kind of playing out? And there have certainly been a few different Supreme Court decisions. There's been decisions on the Tucker Act that make it harder to get immediate relief in district courts, and then that's going to affect the way things go. But I can't answer the question specifically of tracking denials. I mean, it would be a really fascinating question.
We don't have enough time probably for some of those as well. So, okay. I think this one has the word ethics. So I'm going to say this is for Dr. Queen. The principle of executive privilege has been used by presidents to withhold information from Congress. What are the constitutional and ethical limits of this power, particularly in the potential case where Congress is conducting oversight of potential government misconduct?
That's one of those questions where my response is, if I had the answer to that, you couldn't afford me to talk to you. But yeah, I mean, the inability of Congress to kind of anything that kind of inhibits Congress's ability to exercise its oversight over the executive branch ought to kind of first be met with question, right? I mean, the barrier ought to be high, right? And again, I mean, it doesn't mean that there isn't a way to get over it at some point, but really, it gets back to kind of a point I was making towards the end, is that no one wants to be watched, no one wants to be judged, and no one wants to be limited. And the ability to kind of use executive privilege as a way to kind of immunize yourself against appropriate oversight is one of those places where the issues around kind of, I hate to use the word transparency, but issues around accountability and judgment begins to kind of worry one about, is the system functioning the way it's supposed to, right? And I tend to feel that in the absence of compelling reasons to the contrary, things ought to be pretty open. And they need to be open because that is what makes what makes a democracy function in the way it needs to function because people have to believe in it. And so yeah, and again, this issue of kind of claiming it against anything that begins to kind of try and limit me is loathsome, and inherently unethical, right? I mean, the government is supposed to be serving the people, and the people need to know what's going on, and the people or the people's elected representatives ought to have this access. Now, yeah, no one cares what I think, but that's my position.
And can I
We
speak to a slice of that question, which is which is a little bit of the history of the purse here. There's been concern, I would say, since the Obama administration that sometimes disruptions to spending are not directed by the agency, like HHS that administers the program, but directed by the White House,
Right.
like the Office of Management and Budget. And that's one concern, in part because like often Congress's relationship is with the agency, not with the president. So the going through the president is a way to kind of circumvent congressional power and among other potential challenges. So there was the ability for the president to through OMB to hold up funding through something called an apportionment in a way that's legally binding on the agency, but was secret. It was always secret. And that was actually the tool that was used in the first Trump administration. It was controversial around the Ukraine impoundment of the military aid, but in any event, that was always secret. People had been calling across administrations for some transparency. There was actually legislation passed during the Biden administration to mandate that those directives be publicly shared on a website, which then the Biden administration complied with, and it began sharing them. And then a few months into the Trump administration pulled down the website and stopped sharing that. And then in defense said executive privilege. We don't have to share it because the statute impinges on our executive privilege. And then there's a district court opinion in July that just kind of went through it and said, oh, there's my thumbs up again, but did not give thumbs up. It gave a thumbs down to the executive privilege. It said, actually, the constitutional limit when it comes to spending is that the Constitution in Article 1 says Congress has the power to require statements and accounts as to spending. The people have a right to know how spending decisions are being made. And so the district court said that there was no executive privilege as to those sorts of decisions. And that in happy news, happy news if you like law and all, the Trump administration has complied with that court order now and reposted the website, which is again a sign of the court's role kind of working.
Yeah.
Well, I just want to just jump in, and what Professor Lawrence has suggested is really illustrative of what I've argued, is that if there's a system out there that's going to give me an opportunity to not do something I don't want to do, I'm going to find a way to make it happen. And OMB has often been that process.
And I worked at OMB for about 2.5 years, so I know also they have very strong arguments for why executive flexibility and the like are important to efficiency in government programs. So anyway, we don't have time to go through all.
Yeah. I've got another. I'm going to try and get through one more audience question before we have to break. Matt, Professor Lawrence, could you discuss your thoughts about any constitutional mechanisms that exist to resolve conflicts when the executive branch's standards of conduct regarding public service are not abided by? So I guess what's the Constitution doing in this role?
I think it's first up to Congress under the Constitution to pass laws regulating executive branch performance of duties. And we've had different standards over time. For a while, there was a profit motive in a lot of government decision making, and that was a big concern early in the 20th century in the progressive era. And so we have statutes that insist on certain expectations from government servants, and it's up to Congress to write those statutes and then to kind of articulate the enforcement mechanisms for those statutes to see that they work out in practice. I guess the bottom line is Constitution says it's not self-executing. It's up to Congress. That's actually a theme for all of this is in a lot of this, it is up to Congress. And the courts can't necessarily fix lack of energy from Congress to kind of sacrifice and preserve its role, even if it's not politically or expedient from a partisan perspective.
Dr. Queen, anything to add to that?
I mean, there's impeachment, but we've seen how well that's worked out. Yeah, I think, Professor Lawrence is on the key. I mean, what is Congress fulfilling its obligation and kind of overseeing the executive branch? And are they willing to enforce the rules? And unfortunately, there's been a huge dereliction there.
Great. It's 6:45, which means we're supposed to kind of be wrapping up this part, I believe. And although I would ask another question if I had time, but I think I'm going to turn it over now to my colleague, Kenyatta Greer. There we go.
You know what, Joanna? Have at it with your last
Well,
question.
okay. Well, I just have
Good
one more question. I mean, you guys were getting to this at the end. This is kind of my own question. Like, Congress needs to do something. I mean, where do you see things? And I think I mean, like, if two different snapshots, 2 years from now, 10 years from now, like where are things going? Do we, and I think maybe for you, Dr. Queen, if you could perhaps add in, like, if we want to kind of reestablish trust and fix the more the cultural social part of this, like, how do we get there?
I mean, there has to be a will to do so. I mean, as Fukuyama says in his book, The End of History, there's no democracy without Democrats. There's no ethical system without people willing to kind of create one and to ensure that it's enforced and to kind of be willing to have their own partisans be punished when they do it, right? My argument is that clean government ought never to be a partisan issue. And the fact that it's become one suggests how disturbing the cultural moment is.
And I would just add, I think certainly Congress will increase the rigidity of spending laws. So there was a lot of flexibility built into the system so that the executive could adapt and make the most prudent decision in the case. And Congress won't do that anymore because I think they'll feel they got played. So instead of saying, here's money, do the right thing for this park, they'll say, I want a house there and I want this submarine there. Even if it doesn't make sense, they'll need the rigidity because they can't trust the executive branch anymore. That'll probably stick around for a long time. And then I think, but that won't deal with all of it. And I think the really big question is to me, the really big question is in 2 years or 3 years, if let's say there's a Democrat who wins the presidency, or 6 years or whatever, the framers said, will enough people who currently are upset about this still vote for legislation that cramps the executive when the executive is someone they like? And that did happen during the Biden administration, where we got like that website transparency required. That required Democrats to support that, even though it was applied to Biden. So those were Democrats thinking institutionally. The question now is, will there be Democrats who think institutionally when there's a Republican in power? Or in the shorter term, are there Republicans who are going to start to think institutionally, especially as we kind of have a maturing of the current dynamic? And so I think it's that question, do people think institutionally, which really requires sacrifice. To go back to what Dr. Queen was saying about like George Washington, we could go like our system is built actually for selfishness, but it needs, I think it's like 90% selfishness if you look at history, but it needs that 10% of like George Washington, the Freedom Riders. I think like you could say someone like Charlie Kirk going out and being like exposed and things like it needs somebody who's willing to put it on the line, even if it's not in their self-interest, for some sense of the greater good. And you need enough of that or something. So we'll see if that happens to get legislation that really does something substantial in this space to restore the congressional power.
Yeah, people have to be committed to the system, not only to themselves.
At least some of us.
Thank
All
you
right.
so much. That was brilliant. Thank you. I think I'll put those last two sentences on a t-shirt. People've got to be committed to the system, at least some of us. Lovely. This was a beautiful discussion. Thank you for being part of it. I'd also like to thank Dr. Carol Henderson, Senior Advisor to the Provost, for her collaboration and support in the planning of this event. If you who are attending included your Georgia bar number in your registration, you will be direct billed for the CLE credit once it's submitted later this week. Again, I thank you and have a great evening.
Thank you.
Thank you all. Be well.